Okay, so my topic is initiation of CIRP under IBC. Insolvency is a state of being unable to pay the debts owed by a person or a company. It is a situation in which the assets of the company are not sufficient enough to discharge the debts and liabilities by a person or company. The person or company is termed as insolvent. IBC or the code lays down some provisions for the corporate insolvency resolution process, that is CIRP, as well as other guidelines necessary for corporate insolvency. So, in order to know about the initiation process, first we need to understand the IBC. IBC was recommended by Joint Committee of Parliament on 28th April 2016. In the period between 2008 to 2014, RBI drew special attention to non-profitable assets, which was the consequence of random lending by bank, and thus government appointed Joint Committee of Parliament, which recommended IBC. Nowadays, if there occurs a default in making payment of debt by corporate debtor, then application can be admitted as per the IBC. Uh, when the company fails to repay the debt and is unable to do so, CIRP is initiated against the company. Such a company is termed as corporate debtor. An application is to be made before adjudicating authority to initiate such proceedings. Now the question arises, who are the parties or applicants who can initiate the application? Now, the applicant can be first financial creditor. Financial creditor is defined under Section 5, subclause 8 of the code. A financial creditor is a person who owes the corporate debtor a sum of money on which certain interest is received. If there is no interest on the debt, then it does not constitute a financial debt. A financial creditor is given preferential treatment as compared to operational creditor. He has the voting right as well. A financial creditor may or may not send demand notice before filing an application against the corporate debtor. Second is operational creditor. Operational creditor is defined under Section 5, subclause 20 of the code. An operational creditor is a person who owes the corporate debtor any operational debt, which includes a claim in respect of provision of goods or services in relation to employment of any debt. An operational creditor has to send a demand notice, and I quote, it is mandatory. They have to send a demand notice to corporate debtor before initiating any application. Third is corporate debtor or the corporate applicant. The corporate debtor himself can initiate an application before the adjudicating authority. The corporate debtor is defined under Section 3, subclause 8 of the code. A corporate debtor can voluntarily file an application for initiation of CIRP before the NCLT if it can no longer function effectively and can not pay its debt. Now, I would like to discuss initiation of CIRP by financial creditor under Section 7 of IBC. Now, first we should understand who is financial creditor and what is financial debt. Financial creditor is any person whom financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Talking of financial creditor, a new term arises, that is financial debt. A financial debt is a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes certain types of debt which are mentioned from subclause A to subclause I in the code. Now I have cited one case, that is Exim Bank versus resolution of JUKPL. In this case, the NCLT held that the corporate guarantee is a guarantee and so is a financial debt. guarantees further commitment, so the guarantor is also jointly liable. Process of initiation of insolvency by financial creditor. A financial creditor can file an application under Section 7 of the Code. There are two basic requirements for financial creditor to file the application. There must be financial debt owed, and there must be a default made in respect of the financial debt. If the authority, on the receipt of the application, if the authority admits the application, then the criteria must be: first, the application must be complete, and there must be no payment of unpaid debt. And if they reject the application on the following basis: the application is incomplete and there has been payment of unpaid debt. I cited two case laws. First one is Innovative Industry Limited versus ICICI Bank Limited. In this case, the Supreme Court gave full picture of the process for applying Section 7 of the IBC. The NCLT will consider certain requirements before allowing the application under Section 7. Those requirements are: the application must be in proper format in addition to the requirement given. Second, must have much evidence for the presence of debt. Third, must have much evidence for the presence of default. Now, the constitutional validity of Section 7 was also challenged in the leading case laws, that is Shri Metallics Limited and another versus Union of India. But in later stages, it was held that Section 7 of the IBC is not unconstitutional. Initiation of CIRP by an operational creditor under Section 9 of the IBC. Under Section 9, the operational creditor can initiate CIRP for an unpaid operational debt against the corporate debtor. The word operational means able to function and engage in operation. Operational creditor. Operational creditor is a person to whom operational debt is owed, or includes any person to whom such debt has been legally assigned or transferred to. Operational debt. As per Section 5, subclause 21 of the IBC, operational debt means a claim in respect of requirement of goods or services together with employment, or a debt in respect of the repayment of dues arising under any law for the time being in force and payable to the central government, state government, or local authority. I have cited one more case law, Ruchi Soya Industries Limited to Cooperative Robobank, US Singapore branch versus Mr. Shailendra Ajmera. The application was filed by the creditor before IRP and got rejected as it was not financial debt but an operational debt. The NCLT dismissed the application and held that the transaction falls within the ambit of operational creditor. Initiation of insolvency by operational creditor. An operational creditor can file an application under Section 9 of the IBC. There are four requirements for an application by operational creditor. First one, there must be an operational debt owed. Second one, there must be a default made in respect of the operational debt. Third, there must not be any pre-existing dispute between the operational creditor and corporate debtor. The demand notice must be sent by the operational creditor to the corporate debtor before initiation of such application. And the application fees for the operational creditor is 25,000, and for financial creditor, for application fees for financial creditor was 25,000, and for operational creditor is 2,000. Operational creditor along with just a second. The adjudicating authority within 14 days of receipt of application may either admit the application if application is complete and there is no payment of unpaid operational debt, and the invoice or notice for payment to the corporate debtor has been delivered by operational creditor. Fourth, no notice of dispute has been received from operational creditor. and no disciplinary proceedings are pending against the resolution professional proposed by the creditor. And they may either reject the application if application is incomplete, if there is payment of unpaid operational debt, if the invoice or notice for payment of to the corporate debtor has been delivered by the operational creditor, if the notice of dispute has been received by operational creditor, if the disciplinary proceedings are pending against the resolution professional proposed by the creditor. Now, initiation of CARP by corporate debtor or corporate applicant. Uh, after, sorry, the corporate debtor can initiate CIRP against himself after committing a default. For initiating CIRP, the corporate debtor has to make an application in Form 6. If the corporate debtor thinks that he can't dispose of his liabilities from the leftover assets, then he can file an application or admit an application before the NCLT. Process of initiation of insolvency by corporate debtor or corporate applicant. A corporate debtor can file an application under Section 10 of the Code. There are three requirements for corporate debtor to file the application. First one, there must be a debt owed by the corporate debtor. Second one, there must be a default made in respect of the debt. Third, a special resolution must have been passed by the shareholders of the corporate debtor allowing the filing of an application under Section 10 of the Code. And application fees for corporate debtor is 25,000 as well. Now, the adjudicating authority shall, within 14 days of receipt of application, may admit the application if it is complete and no disciplinary proceedings are pending against the IRP proposed, and they can either reject the application if it is incomplete and if the disciplinary proceedings are pending uh, against resolution profession. Okay, so till now we have learned about who are eligible to make an application. Now let's go with who are not authorized to initiate an application under such code. So the person who are not authorized to make an application to initiate CIRP are corporate debtor undergoing a CIRP, or a corporate debtor having completed CIRP 12 months preceding the date of making the application, or a corporate debtor or a financial creditor who has violated any of the term of resolution plan which was approved 12 months before the date of making of application, or the corporate debtor in respect of whom liquidation order has been made. I would like to conclude by saying that it can be inferred that corporate insolvency resolution process is a detailed process. There are various steps. There are various steps to be followed during the process for the fruitful outcome. The provisions and regulations provided are essential, and the requirements are also essential. If the CIRP is conducted in a proper manner, then it will result in the revival and reconstruction of the corporate debtor. Thank you. Sir, I have made research paper as well. No, sir.
So I just wanted to ask Shrishti, can you just say what are like your inputs or advices on that CIRP that presented?
Okay, so I chose this topic as many of Indians are not aware about IBC, and so IBC is only for is not for liquidation, but for giving solutions for from preventing liquidation. I just chose this topic to make everyone aware that it is that being unsuccessful is not shameful, as people take it as taboo that they are facing failures and they'll face liquidation as well. So this code is basically for resolution, not for liquidation. That's all was the motive of me to make you understand.
Yeah, okay. Yes, sir, that's it.
No.
Sir, sir, do I have to present again after making any research paper again? Okay, sir. Apologies. I'll take care from next time. Thank you, sir. Thank you, sir. Thank you, sir.
Yes, sir, I can do it. Uh, I, yeah, sir, I'm just facing some problems with sharing it. Can I send it to you so that you can share it? Yeah. Yeah, I have the common one. I'll send that submissions I have. Okay, Jagdish Naidu, zero. Okay, yeah, okay.
Yes, sir. I want certificate. Um, I'm not getting what you're saying. No, sir. No, sir. No, sir.
in my paper on the topic collegium system, whether is it the apt procedure to be followed in contemporary India. So my paper itself consists of a question, and you can pour in your opinions. Just a preliminary suggestion whether it is app system, that one must follow in India, or do you have any other system in mind or suggestions in mind? Uh, uh, so that was like a question. So like if anybody wants any opinions, any any suggestions.
I cannot see. No, I was saying I cannot see the question. It's the topic. Okay, I thought, okay, I'm sorry, it's my fault. I thought research questions. Okay. No, no, I don't have anything.
Guys, do you know what is a collegium? Maybe I can explain that and probably we'll. I'm not sure. Yeah, so basically, collegium system is wherein for appointing the judges or transferring the judges, like a group of judges would be elected, and they would decide who will be the Chief Justice of India, or who should be elevated from a particular high court to the Supreme Court. So that is what a collegium consists of. It's basically a group of judges who elect in a particular judge to go to a Supreme Court or High Court, like to post them. Yeah. So you can move to the next slide. So my research questions are, first is whether the practice of appointment of senior most judge as the Chief Justice of India, whether that's violating the doctrine of checks and balance, which means that if appoint whether is it vesting with the judiciary any excessive amount of power or not. Then second question is that whether the mandate of seniority as a main factor, it should be shifted to multiple factors like any other factors like the qualification that they're having, or any other academic factors, whether that also should be taken into consideration by the collegium, especially in a dynamic society like India where abortion laws are there, or LGBTQ laws are there. So any judges who have greater knowledge on that fact should be elected, say as a Chief Justice of India, or should we follow the traditional process of appointing the senior most judges as the Chief Justice of India? And my third question is whether the executive needs to be given more room by indulging in the appointment process, and by doing so, we can make the process more democratic or not. Moving on to the next, the research objectives. The next slide, please. So my first objective is to analyze the past trends of appointment of judges, especially before the year of 1993, because it was in that year that the landmark judgment of Supreme Court record on association case had come, through which this collegium system is introduced. And my second objective is to examine the present collegium system and to suggest alternatives to the system, and thus making it more democratic and efficient. So next slide, please. So let us understand what is collegium in order to understand the topic. So as I have explained earlier, collegium consists of a set of judges who are responsible for appointing particular judges to High Court or Supreme Court, or transferring them. And the collegium system is the process through which those particular number of judges appoint or transfer the judges. And in case of a Supreme Court, it's carried out by a forum of quorum which consists of Chief Justice of India and other four senior judges of the Supreme Court. And if it comes to the High Court, then it is carried out by the Chief Justice of that particular High Court and four other justices of that High Court. So next slide. So we'll see how this collegium system has evolved. So I have divided it into four stages. The first stage being the traditional practice, wherein the senior most judge of the Supreme Court was appointed as the Chief Justice of India. This is a process that we can see right now as well, but there is one main difference. At that point of time, the executive had primacy over appointing the judges. What this line means that the president can elect the Chief Justice of India. The president can elect the senior most judge of the India with the consultation of Chief Justice of India. But this consultation was just for namesake. If any suggestion was even if any suggestion was given by Chief Justice of India, it was not given much of importance. Whereas now that has changed, and the consultation made by the Chief Justice of India is important. And moving on to the second stage, this is where there was break in pattern. Now, at initial stage from 1950 to 1973, the senior most judges continued to be the Chief Justice of India, and it followed until in the year 1973, in the Keshavanand Bharati case versus the state of Kerala, Justice A.N. Ray, after that particular case, Justice A.N. Ray was appointed as the Chief Justice of India, although he was just the fourth most senior judge, and and it was because of his favorable judgment for the government in this particular case. So that's why you can see how there is a misuse of power that is taking place, and how he had become the Chief Justice of India. And second case, it was the ADM Jabalpur case, which took place in 1978, wherein as a result of which Justice H.R. Khanna was superseded by Justice Beg, and he had become the Chief Justice of India. So again, a misuse of power can be seen. So next slide, please. So continuing, this is the stage 3. After 1978, again stage 1 restarts. The senior most judge starts to become the Chief Justice of India. And finally, the fourth stage came from the year of 1993. There were 4 important cases which led to this collegium system, and how the collegium system had started in the year of 1993. And it's highlighted in the slide as the follow: S.P. Gupta versus Union of India, Supreme Court Advocates on Record Association versus Union of India, and Special Reference 1 of 1998. So next. So when we're discussing about whether the collegium system is good or not, in 2014, the Modi government, they had made an attempt to pass a bill called as a National Judicial Appointment Bill, making in which a National Judicial Appointment Commission was being made, and it was enacted in December 31st, 2014, and as per the said act, and as per 124, Article 124, the President had to seek the recommendation of the members of the committee instead of asking the Supreme Court or High Court judges while appointing any judge. So now the consultative power shifted from Supreme Court or High Court judge to the members of the NJAC. And this was later on, as we all know, it was later declared unconstitutional by the Supreme Court because of the lack of judicial independence. So next slide, please. So this flowchart represents the composition of the National Judicial Appointment Commission as per Article 124A, and as it is clearly visible that it was consisting of Chief Justice of India, 2 senior judges present, President of the Supreme Court, Union Minister of Law and Justice, and 2 eminent persons. So among which one belonged to the minority category, and one can be either Prime Minister, Chief Justice of India, or leader of opposition in Lok Sabha, or leader of largest opposition party in Lok Sabha. So looking at this chart, it's we all will think that it's a nice structured composition, everything is perfect. But the main reason over here was that lack of judicial, there was a high tendency for lack of judicial exercise because when they say any two members, it can be prime minister and maybe leader of opposition party. So there is no presence of judiciary. So appointment of judges without the presence of judges itself. Uh, so next slide. And I have already explained this, and there was so a constitutional crisis was arising, as I had said that one entire organ of government was missing over here. That was judiciary was missing over here, and as a result of which it was hampering the democratic framework of the country, and there were higher chances of corruption and politicization if the bill was not declared unconstitutional, and as a result of which this particular bill was declared unconstitutional and the collegium system started again. So next step. So now in my paper, I'm criticizing this particular collegium system with few inputs that I have personally put forward with my research. So first is that continuance of the collegium system had imposed greater responsibility on the judiciary, and appointment of judges needs to be more transparent and integral in nature. The collegium system, even though it involved the judiciary, what happened was that no particular amendment, no particular act, nothing was implemented, or the common citizens of the country don't know what is happening to the institution who themselves are responsible for delivering justice and standing for the right. So they don't know. We all know who is the Chief Justice of India or who are the judges of Supreme Court or who are the judges of High Court, but we never know, okay, how are they getting elected or any certain criteria that has been set up. So this is one of the major drawback of the collegium system. And certainly when such a opaque system is being followed, then what we can see is that favoritism comes up, nepotism comes up. The judges will also start to speak in such a language that uh, that can improve their chances for getting elevated or to a better position. So yeah, next slide, please. So then I am proposing that comparing with other countries, say in right now I have compared it with the US and UK. So comparing it with the United Kingdom, there is an independent commission which is called as a Judicial Appointment Commission. So what this commission does is that the people present in this particular commission, they will recommend the names to the chancellor. The chancellor has the right to reject the names or suggest the names, or to accept the names. But he can reject these names only when there is a very valid reason or when there is any serious crime that is leveled against a particular judge who has been recommended by that committee. Then second is then so this particular commission is similar to the NJAC, which was proposed by the Indian government in the year of 2014. So next slide, please. So now moving on to the United States, the president nominates the judges, and after these judges are being nominated by the president, then they have to be approved by the United States Senate, and the candidates would get the confirmation of their appointment from the Senate Judiciary Committee. So from both these countries, what we can see clearly is that the executive as well as the judiciary, they're working parallelly. Nobody is kind of subordinate to the other. So looking at these two countries, India should not just blindly transplant whatever principles are there in those countries, but they must see some of the procedures which are happening in other countries, try to involve in their legal framework, at least mold in such a manner which is suitable to their geopolitical situation, and make a committee or make a institution in such a manner where there is a balance between the executive and the judiciary. The next slide. So now I would like to conclude over here, and the way forward, and this involves my inputs, in which the main reason everybody is criticizing the system is because of its opaque nature in the system. Nobody is aware till date how the Chief Justice of India, or on what basis is he elected. Just the other than the senior most judge criteria, is there anything else that is involved? Or there are still many controversies that's taking place, which we need a clear answer. Second is that, so a suggestion which is there is that to overcome this drawback, it's suggested that an amendment needs to be made or act needs to be introduced, which puts down all the procedures through which a judge could be appointed, or he will be transferred by the judiciary in the collegiate system. And third is that involving other organs of the government without compromising with the judicial independence. It is integral part of the democracy. It is really ironic that the world's largest democracy is having an undemocratic process itself in the judiciary. So a written act would keep away the problems of discrimination, partiality, nepotism, favoritism, and etc. And it would lay forward a path of equitable process and a fair process. Thank you. I would like to end my presentation. Thank you so much, sir. I'll improve on it. So, so in that internship diary, there's this column for the feedback or something from the internship person. So only that one page needs to be filled. That's it. And there's a seal is also required. Yeah, yeah. So not like a personal. There's this format there, just the like the feedback of the student performance. So yeah, yeah. Yeah. Okay. Okay, so I'll mail it to you.
Yeah. What? Yeah, yeah. Is the PPT visible? Okay, so good evening, everyone.
I'm Kajal Agrawal. I'll be presenting on the topic Medical Negligence under Consumer Protection Act 1986. The aim of this project is to study the yeah, it's fine now. Okay. So the aim of this project is to study the concept of medical negligence and analyze its scope under the Consumer Protection Act 1986. And the research questions that will dealt in this project is what is medical negligence? When does a medical service fall under the Consumer Protection Act 1986? What are the complexities related to the procedure of establishing medical negligence, and how have courts interpreted the concept of medical negligence? So to start with, we'll give the introduction of what medical negligence is. Medical negligence is the misconduct by a medical man or doctor for not providing enough care and harming their patients, which are their consumers. A professional should be an expert in his job. A patient expects to be healed and he trusts his or her doctor. Medical negligence has caused many deaths and have severe harm to their patients. Medical negligence is also known as medical malpractice, is the unskilled, improper, or negligent treatment of a patient by any nurse or pharmacist or doctor. Um, when does duty arise? It is very well known that a doctor owes a duty of care to his patient. There was one case, Samaira versus Dr. Prabha Manchanda, where the consent was not there. What they did was they took the consent from someone else and not to the patient. He was not minor. He was just on the anesthesia, but they took the consent from someone else. So they were charged for that. 25,000 compensation was given to the uh, patient. And what is the duty owed? In general, a professional man owes to its clients a duty in tort as well as in the contract to exercise reasonable care in giving advice for performing services. A medical practitioner has a duty of care in deciding whether to undertake the case, a duty of care in deciding what treatment to give, a duty of care in the administration of that treatment. Medical negligence as under Consumer Protection Act 1986, the landmark case of Indian Medical Association of versus VP Mahanta, brought the medical professionals within the ambit of service as defined in the Consumer Protection Act 1986. Medical negligence may be classified as negligence of the medical practitioner, negligence of the nurse and the staff, negligence of the hospital authority. The extent of the negligence and accountability of the medical practitioners, nurse and staff, and the hospital authority. Some judgments, are not read out all the judgments. It's an important one. Indian Medical Association versus VP Sahanta. As a result of the judgment, medical profession has been brought under the Section 2(1) of Clause 1(o) of Consumer Protection Act 1986, and it included the categories of doctors' hospital under this section. All medical or dental practitioners doing independent medical dental practice. Second, private hospitals charging all patients. Third, all hospitals having free as well paying patients, and all the paying and free category patients receiving treatment in such hospitals. It extends only these hospitals and the medical or dental practitioners of such hospitals which offer free service to all patients. In this judgment, all private and government hospitals and the doctor employed by them and the independent medical or dental practitioners expect primary health center, birth control measures, anti-malaria drive, and such other welfare activities can be sued under the Consumer Protection Act. There's also Shubhlata versus Christian Medical College case. In this, the husband died due to the complications arising after kidney biopsy. The state commission held that the complainant had suppressed the crucial facts in her complaint, as he was beside the biopsies, he has serious diseases uh, that is related to heart, lung, and brain, and that is very dangerous since the complainant had not come with clean hands. He disentitled herself to relief under the jurisdiction of the Consumer Protection Act. A conclusion to this, the relationship between the doctor and patient has undergone drastic changes due to the corporation of medical profession, resulting in commercialization of the noble profession, and such against the letter and the spirit of Hippocratic oath. Though rapid advancement in medical science and technology have proved to be, but I don't think so. It's evolving. All the cases we have seen, it's very dangerous. Medical negligence is the misconduct, and it has the severe punishments. But it is important for the doctors to be careful and patient with their jobs, as they may risk someone's life to their because of their negligence. There's also liability in through civil liability is also there. It has been given, and criminal liability is also given. It was in the case of Suresh Gupta case. And also, there was one case, Krishna Iyer versus State of Tamil Nadu, where she lost her eyes, and the apex court awarded her 1.8 crores of compensation, and which is the highest paid compensation. With that, I'll end my presentation here. Thank you. Mm. Yeah. No, no, no. I don't need. It will be great if you can provide the feedback thing. Okay, sure. Thank you so much. Thank you so much. Oh, thank you.
Excuse me, sir.
Sure.
Yes, sir. I have a question. So, do I need to attend the rest of the three classes? So, we don't have to attend tomorrow and day after tomorrow's presentation session, no?
Okay, okay, sir. Thank you, sir. Okay. Thank you so much. Okay.